Hello, everyone, and welcome back to the preparation for the CLAT examination. In this particular lecture series, we are talking about the legal reasoning portion for the preparation of CLAT examination. As you already know, that the syllabus comprises of five major fields when you talk about CLAT. First being your general English, second being your journal awareness, third being the legal reasoning portion, and then you have the logical reasoning. Apart from that, you have the quantitative aptitude that you have to be dealing with whenever we are talking about the syllabus of the CLAT examination. In this particular lecture series, we are tackling with the legal reasoning portion of your CLAT examination, perhaps the most sought after and most interesting syllabus or part of your CLAT preparation. Throughout this lecture series, we have covered a lot of portions. We have completed the Indian Contract Act, we have completed the criminal laws, we have completed the Constitution, and we have completed the law of torts also. And from now onwards, we will be dealing with perhaps the most interesting portion and most sought after portion by majority of the CLAT aspirants, and that is the family law. Because once we talk about family law, we have to understand how the law is governing the families at large. You have a lot of things that you see when you talk about family, that who will marry who. So how the marriage will take place in a family, that is also being governed by some laws that has been incorporated. And first and foremost thing, whenever we are talking about family, and you know that India is a diverse country. In India, when we were studying Constitution, we studied that India is a secular country, meaning which there are lots of different sort of religions, different type of religions that are domiciled and resident in India. We have Hindus, we have Muslims, and we have a lot of other religions who are living peacefully together with a lot of brotherhood, and they are cohabiting together. And for that, we need to make sure that there are laws which are governing how the marriages are going to take place, how even if the marriage is not feasible and it is not going forward, how to put an end on that marriage, how to get a divorce. And if at all there has been a divorce, is there anyhow possibility that the person who have faced a lot of issues and challenges during that marriage, by any way possible, can we compensate that person? So we are talking about maintenance also when we talk about family. And if somebody dies, how the property will be inherited by their successors, meaning which if there is a person who dies, whether his property will be given to his brother, his father, or his son. All these things have been mentioned and has been compiled under the family laws. So when you talk about family laws, I suppose you are able to see the screen, guys. The first and the foremost thing when we talk about the family law here, first we need to understand that what are the things that we need to study, because it is a very vast subject. And when we say vast subject, what we need to understand is that we have to focus family law only on the basis of CLAT, not the whole family law. Because when we talk about family law, I'll let you know so that you have a better idea. And when you talk about family law, you have first the Hindu laws, then you have the Muslim laws, then you have Christians, Parsis, and then you have Special Marriage Act. Then apart from that, there are different legislations for succession. So one has to be very clear that what we need to study, what are the things that we are going to cover whenever we are talking about family law in relation to the CLAT examination, because we are not we will not be focused over that how the divorce will take place, but we need to understand what exactly is divorce, and what are the grounds on which a person can claim divorce from his or her spouse. Here spouse means the wife or the husband, and how what is exactly the process. So the questions that the CLAT consortium often asks the student is not about how what exactly is divorce, but rather how the divorce will take place, what are the grounds of divorce, how the marriage will take place, what are the conditions of a marriage. So these are the important things which a CLAT aspirant should take into mind whenever they are preparing for this examination. So when we talk about family law, let's try to understand and let's try to analyze that what are the things when you talk about family law, then what are the things that we need to study so that we have full confidence that whenever there will be a question that will be in relation to the family law, we will be able to answer them in a very crisp, clear and crystal manner. So we are talking here about the legal reasoning portion, as I've just informed you, which will be inclinated only towards the CLAT examination. In that, we are studying family law from today onwards. And in family law, what we are going to study is, first and the foremost thing that we're going to study is the sources of the laws. Here, we will be studying majorly the Hindu law and the Muslim laws, because the questions that you will be seeing in your question paper will comprise from these two portions only, and maybe some portion from the special laws will also be asked to you. So the first thing that we are going to study is the sources of the laws. Post that, what we are going to study is how the marriages under the Hindu law, under the Muslim law, and under the special laws take place. Okay. So the second thing that we're going to study is the marriages. After the marriage is completed, after the marriage, what we're going to study is how the divorce will take place. Okay. So in that particularly, we will be focusing over the grounds of divorce, and who is eligible to give divorce. Okay, so this is clear. We're going to study the sources of law. We are going to study the marriages, how the marriage is going to take place. When we talk about the Hindu laws and the Muslim laws. And post that, we are also going to study about succession, because succession is perhaps an important portion when you talk about CLAT, because one needs to understand that if at all there is a demise of any person in their family, and that how the property which that particular deceased, the person who died, has, to whom that property will be going. If we are talking about any property, so you must have heard whenever you are watching any movies or you going through any serials, that there is a talk of one word which is known as a will. So when you have a will. So what is a will here? A will is a document, is a piece of document. It is a piece of document which contains how the assets of the person after her demise will be given to other persons. And when you talk about other persons, it can be anybody. It is not like that when you talk about a will can only be in the name of their siblings or their brothers, sisters, mothers. No, it is not like that. A will, if you're making a will means that if it is a piece of document which is a registered document, that once I die, then my property, whatsoever I have claimed and I have achieved during my lifetime, to whom that particular property will be transferred once I pass to the heavenly abode, once I die. So for that thing, you make a will. But there are chances that sometimes the person is not able to make the will and he dies consequently because of maybe sudden incident that took place, maybe because of illness, maybe because of an accident, or the person forget to make a will, or the will is not registered. So in that scenario, how the property will be segregated, how the property will be transferred from one person to another, who will be the claimants, to whom the property will be transferred, each and everything has been made in a very crystal crisp and clear manner under the succession laws. So when we are talking about succession, we will be talking about one thing which is known as intestate succession. Okay. What is intestate succession? Now this is a question mark here. What do you understand by intestate succession? Okay. So let's try to understand this point first, because this is just an overview, guys. So don't worry that so how will we be able to tackle all these things, because we have no idea how the things are. But this is just an overview. This is the first class, how we are going to approach towards the family law, how we are going to make sure that everything whatsoever will be coming in the CLAT examination, you are able to tackle it in a very crisp, crystal and clear manner. First, we need to understand what exactly we need to study. And I'm just trying to explain you the things so that you have a little bit of knowledge that when we are going to study it, we have a background that, okay, this is that. So this is what I'm trying to explain you here. Marriage, you understand. Divorce, you understand. But what about succession? When the succession will take place according to the law? When will it take place according to the will? So when you talk about succession, and let's take an example, here is a person A, okay? And this person dies. Okay, let me make a figure. So whenever I am going to make a bracket for you guys, it means that the person has died. Okay, so when the person has died, and we have mentioned a person like A, and if we make it like this, so it means the person has died. If it is like this, the person is still alive. Okay, so it is for your better understanding that how we are going to make a diagram for your better understanding, how we are going to approach the things. Okay, so for the first thing is that let's say assume that there is a person A. Okay, he is still alive now, but consequently after a certain age period of time he dies. Mr. A has a brother of A. Then you have then there is one person of son of A, and then you have the wife of A. What happens is that A is not able to make a will and he dies. And he has a property. And he has a property of he has a property of 10 lakhs. Okay, 10 lakhs, no? Yes. So he has a property of 10 lakhs. How this property will be divided, whether it will be going to the son of A, whether it will be going to wife of A, whether it will be going to the brother of A. So all these questions, all these things has been answered under the succession laws. So one has to understand that if at all, if A is able to make a will, okay, and in that will, he mentions that all the property of mine after my demise will be going to my brother, not to my son, not to my wife, but to my brother, then the property whatsoever he has earned, that whole 10 lakh rupees will be going to his brother only and nobody else. This is only when you have a will. When you have a will. But if you don't have a will, if A dies without making a will, then the laws of succession the laws of succession will govern and they will provide according to the intestate succession. Okay, according to the intestate succession means according to the laws of succession, that how the property, how this 10 lakh rupees or the 10 lakh amount property will be divided amongst A, the son, the wife or the brother. Okay, so if the property has a will, a person before he dies, he is able to make a will, then that property will be segregated and will be divided according to that will only. But if the property has been divided, if the person is unable to make the will, then the property will be divided according to the laws of succession, which is known as intestate succession. But if the person is able to make a will, if he is able to make a will, then that type of succession is known as testamentary succession. Okay, this is known as testamentary succession. So why we are studying it again? Let's try to summarize. Let's try to understand that why is it important to understand that what type of succession is known as intestate succession, what type of succession is testamentary succession. A simple difference is when you have the will, it is known as testamentary succession. When you don't have the will, it is known as intestate succession. When you have the will, no succession laws will govern. Only requisite that you have to make sure that the whatsoever has you mentioned in your will, a piece of paper, a document which is describing how my assets, if I die, will be allocated to my relatives, to my siblings, to my wife, to my to my knowns, has been mentioned in the will, and it has to be registered. The only requisite is that it has to be registered and it has to be signed by the person who is making the will in front of at least 2 witnesses. So if these things are there, then the will can be considered as a valid piece of document, and it can be used to make the transfer of the property. But if the person is not available, then the property will be divided amongst the heirs. Okay, now you understand heirs. What heirs means? Heirs means the person after A, if he has a wife, a son, and a brother, and nobody else, all these 3 will be called as heirs. Heirs who are going to inherit the property of a person after his demise, after his death, is known as heirs. Okay, so all these terminology, all these things that we'll be studying, but just for an overview I'm telling you. So all these things are going to be governed through succession. So once we start with our lectures, once we get a thorough idea that what exactly is succession, how the property, what exactly is a property, all these things we will be covering when we will be studying the succession laws. Okay, so this is another point that we're going to study in our upcoming lectures. So first is marriage. First is sources of law, second is marriage, third is divorce, fourth is succession laws, and the fifth one is maintenance laws. You must have seen some movies where which a person after he marriages, he has been asked to provide a certain sort of amount to his wife if they happen to get a divorce with each other. Once they die, once they are not living together, once they are not cohabiting together, and the marriage is not going smoothly, then the person is not able to maintain himself or herself, then there is a provision of asking for maintenance. Okay, in Hindi it is termed as a bhatta, but when you talk about maintenance, there are certain laws which are providing how the maintenance will be provided and who has to pay the maintenance in regards to maintaining the family itself. Okay, so maintaining the family. So let's take an example. The husband marries wife, and after a certain period of time, husband is not providing the essential commodities, the fooding, the clothes, the shelter to his wife, and the wife had but no other means to live with that person, and then obviously it will be injustice towards the wife. So in order to make sure that once the marriage is taking place, both the spouses are cohabiting together in a very happy, prosperous, and healthy environment, we have to make sure that there is a good amount of maintenance. A person is able to maintain himself or herself. If the person is not able to maintain himself or herself, then there is a provision in the law which provides that the spouse has the responsibility, or the main head of the family has the responsibility to maintain the person who is unable to maintain. And under the maintenance laws, we will be studying the Hindu law, the Hindu laws of maintenance, Hindu laws, the Muslim laws, and apart from that, we will also be studying section 125 of CRPC. That name has been changed, and according to the Bharatiya Nyaya Suraksha Sanhita, we will be studying the provisions that has been mentioned under section that were mentioned under section 120 of 5 of CRPC, which has now been converted to Bharatiya Nyaya Suraksha Sanhita, and we will try to understand that how the generalized concept of maintenance has been provided under section 125 of CRPC, now being termed as Bharatiya Nyaya Suraksha Sanhita. Okay, so this is what we're gonna study under the maintenance laws. But first, what we need to understand here is that when we talk about family, so you know that we have different religions. I've just informed you, India being a secular country. So all these laws, what we are going to study is something which is known as personal laws. What do you understand by the term personal laws? Personal law means that it is not universal in nature. Universal in nature. For example, when you talk about Constitution, when you talk about Indian Contract Act, or when you talk about the Bharatiya Nyaya Sanhita, which was earlier called as IPC, what is one thing that is common, and that is universal applicability. But you will not find when you talk about the family laws, it is not universal in nature. Meaning which it will, if you talk about Hindu laws, it is not going to be governing the Muslims. If you talk about the Muslim laws, it is not going to govern the Hindus. So every religion has a certain set of personal laws, and based on those personal laws only, we are going to understand all these things, whether it is about the marriages, whether it is about the divorce, whether it is about the succession, whether about the maintenance. Let's take the example of marriage. When we talk about personal laws of marriages under the family law for Hindus, the first law that governs the Hindus' marriages, it is the Hindu Marriage Act of 1955. So the Hindu Marriage Act of 1955 is that personal law which is going to provide the rules and regulations that is going to govern whenever there is a marriage that is going to take place between two Hindus. Okay, so whenever there is a marriage between two Hindus, it will be governed solely by the Hindu Marriage Act. Whenever there is a marriage between two Hindus, it will be governed solely by the Hindu Marriage Act. And this act is a personal law. Okay, this act is personal law, meaning which it is only being governed for the Hindus in the society. It shall not govern the Muslims or Christians or any other religion. So that is what we need to understand when we talk about family law, because it is such a wide subject, and it is a completely different branch of law. Like the people have speciality in the commercial laws, they have contract, they have torts, they have sales of goods act. I know that this is something that is beyond your syllabus. I'm just trying to explain to you, because once you're able to understand that the whole crux, the whole reason of keeping them different and not making on a universal basis. Perhaps there have been talks in the parliament which is saying that we need to create a universal law so that the applicability of the people over the people and according to the marriages will be there. But then obviously there is a conflict between the parliament and the judiciary, stating that the personal laws, if we are going to universalize it, it is going to change the secular structure of the constitution. And as you know, that in the S.R. Bommai case, it was held that the constitution in India being a secular country, that means that in India, every religion shall be treated equally. So once you're taking this religion portion and you're talking about the customs, and when you talk about the customs, the rituals that you follow whenever you are marrying, the rituals are different for every religion. So for example, if you talk about Hindus, then there is a fire, and beyond that, on that fire, there are 7 rounds, which is taken by the husband, and the wife whenever they are going to get married. So this particular provision has been specifically there under the Hindus. So according to the Hindu Marriage Act, this is an essential ground that you should have saptapadi or anything equivalent to that according to your customs, so that you have a valid marriage. There are other grounds that we are going to discuss, but this thing, obviously, it is only confined towards the Hindus as such. When you talk about Muslims, in Muslims, marriage is considered as a contract. And when you talk about contract, there is a provision of saying kubul hai, kubul hai, kubul hai by the husband and the wife. Then only the priest, the person says that yes, this marriage has been consummated and this marriage is complete. So there is a different ritual that has to be followed altogether. So following a simple and a universal legislation or the law in regards to all the marriages, in regards to all the religion, is practically impossible. So that is why whenever we are talking about the laws which is going to govern the family, which is going to make sure how the marriage will take place, how the divorce will take place and everything, it has to be not governed by something which can be universal in nature, but we need to make sure that there is a reasonable classification. We have studied reasonable classification when we were talking about equality article. So reasonable classification has to be there, and based on that reasonable classification itself, we have segregated personal laws according to the said legislations. So whenever, if there is any person who is a Hindu, so when we say about Hindus, what we have done, we have reasonably classified them. So all the Hindus, if they are going to marry, they are going to be governed by the Hindu Marriage Act. So if you are a Hindu, if you have attained the age of 18, and there are certain other essentials that has been mentioned under the Hindu Marriage Act, this is what we are going to study. You need not worry, just an overview. Then everybody shall be governed by this law. So there might not be a universal applicability, but when we reasonably classify the people according to their religion and then apply these laws become reasonable and the laws becomes applicable. So when you talk about Hindus, it is going to be governed through the Hindu Marriage Act. If you talk specifically about the divorce, the marriages, and if you talk about and if you talk about the other things, if you talk about succession, so you have Hindu Succession Act, And when you talk about maintenance, you have Hindu Adoption and Maintenance Act, 1956. This is 1955. So according to these laws, all the Hindus shall have the right to succeed, and all the Hindus shall have the right to maintenance. So this is what we need to study when we talk about family laws at large. So the major things that we're going to study when we talk about the personal laws, or if we talk about the family laws, the major things are this. First, we're just going to study the sources. Then we will study how the marriages will take place. Then we will study that how the divorce will take place. Then we will see through it that once the person dies and he has not made a will, the will is not there, how the property will be divided amongst the inheritors, and if at all there has been a marriage, and if somebody is dependent over someone. Okay. Yes. So we were discussing about family law. Here, what we are going to study, we were discussing about that. So what we are going to study here, first thing is the sources. Second, what we're going to study, how the marriages is going to take place among the different religions. Third is how the divorce is going to take place. Fourth is how the succession is going to take place. And the fifth one is how the maintenance can be asked or claimed. Now, when we talk about maintenance, let's try to understand why we are talking about maintenance also here. That there is a one person A, okay, and that person has 3 people in his family. First is the son of A, second is the wife of A, and the third being the father of A. Okay, father of A. So when we say father of A, and if you see this sign, what do you mean? It means that the father has died. The father has died. But this father, he has, this is A, it is the father. So let's change the direction so that it is better understood for you guys. This is A, this is the wife of A, this is son of A, this is daughter of A, and then you have father of A. Okay, father has died and father has a brother. Okay, now the brother is alive. Now this particular person A has to make sure that he has son, wife and daughter. All of them, son, wife and daughter, are the heirs of A. This is clear? Till this point this is clear? Yes. So since they are heirs of A, it is the obligation of A. It is A's obligation to make sure that the dependents over A are able to get the minimum standard of living. They are able to get education, they are able to get food, they are able to get shelter, they are able to get all the essential commodities which is required for a one person to sustain his life. Meaning which he is able to maintain himself or herself. But let's take an example that A is providing all the essential commodities, all the essential elements only to his son. He is providing good education, fooding, shelter, etc. to his son and to some extent to his wife also, but not to his daughter. He is not providing the important things to his daughter. Now, what will the daughter do? Question is, what will the daughter do? Can she take any actions against the father? Does she has any rights? what she needs to do in order to make sure that she is getting enough opportunities and enough support so that at least she is able to maintain herself. If the daughter and A being Hindu, the daughter can approach to the maintenance laws, and if we talk about Hindus, she can approach to the legislation of Hindu Adoption and Maintenance Act of 1956, which provides that if there is a dependent who is a minor meaning which she or he has not attained the age of 18 years, then they are considered as dependent, and it is the duty of the guardian to maintain the dependent. So the daughter can approach to the court, and by this legislation of Hindu Adoption and Maintenance Act, she can even claim maintenance from her father. So we need to understand all these legislation, all these laws in such a manner that without investing a lot of time in the family laws, because see, family being a very interesting topic, often I have seen that the students get diverted and deviated from the main things that we need to study, and rather they get interested in studying, okay sir, how will this happen, how will that happen? And that is something, it is totally natural. It is something which I wouldn't say that it is wrong. And if you have the curiosity and if you want to ask questions, then you should ask. But perhaps that can be done after a certain period of time, and you will have all the time to study the family laws once you have cleared the CLAT. So we should focus our mind only to those areas. We should focus our mind only to those areas which are able to provide us with that knowledge which is going to be helpful for us when we are preparing for CLAT examination. So what we have to study only are strictly relating to CLAT, that is the sources of law, marriages, divorce, succession, and maintenance. So let's start with our chapter, with our topic of family law. And first and foremost, we are going to deal with the sources of family law. Sources of family law. So let's erase it and write it again so that it is better understood for you. So when you talk about sources, what are the sources of Hindu laws? First we will study the Hindu law, and then we will be studying about the Muslim laws. Because perhaps the questions that will be put forward in front of you will not be from the other religions. There might be some questions, but majority of the time they won't ask you, because there is a very wide syllabus, and there are a lot of things that the CLAT consortium can ask you. So we are not going towards those directions which will not be fruitful for us. So if we are able to understand the sources of law of Hindus laws and Muslim laws, then there are high chances that you will be able to score a good amount of marks, more than 80%, more than 90% in your family law portion. So that is why we are restraining ourselves only to the Hindu laws and the Muslim laws. Once we have completed it, and once you have a sufficient time period, what you can do is you can just go through superficially with the other personal laws, so that if at all you are not confident, okay, now you want to score extra and you want to make sure that everything is perfectly prepared before going to CLAT examination, that you have, then you can obviously move forward. But in this particular lecture series, we will be confining ourselves only to the sources of the Hindu laws and to the Muslim laws. So let's start with the sources of Hindu laws in this lecture series. So for that, first we need to understand how the sources actually evolved. For that, I would be drawing this particular line, and now you must be confused that what exactly is this. So what we're going to take is, this is a middle point. Okay, so this is exactly the middle point, and this is something when the Christ was born. Okay, Christ, Jesus Christ, you must have heard the name. So before the Christ was born, before the time, it is known as BC, and after the time it is known as AD. This is something that you have already known. This is something that you have studied. Yes. So the time which is before the Christ, it is known as BC, and the time which is after the Christ, it is known as AD or Anno Domini. Before the Christ, BC is before the Christ, AD is Anno Domini, which is after the birth of the Christ. So when you talk about the sources of Hindu laws, first and the foremost sources of Hindu laws comes up more than 6,000 BC. Okay, 600 BC. So when we talk about 600 BCs before the Christ, we had the sources of the Hindu laws, which was termed as Shrutis. You must have heard the name, but now we need to understand that what exactly was Shrutis. So these were the ancient. These are considered these particular sources, the sources of family law. The sources of Hindu law has been classified as two major portions first. Let's try to understand in a chronological way. Two major portions. First is the ancient source, and then you have the modern sources. So ancient source and the modern source, both sources combined provides us with the terminology, with the rules which is going to govern the Hindus, and specifically in regards to their marriages, divorce and everything. So for that, we need to understand what exactly are the sources. We have understood that there are two major sources which are going to govern the Hindu laws, first being the ancient one and the second being the modern one. Now let's try to understand what are the ancient sources of Hindu law. So when we talk about the ancient sources of Hindu law, we needed to understand that there is a timeline which has been divided on the basis of the Christ's birth. The first timeline represents before Christ and the second one represents after Christ. And before the Christ was born, 600 years back, there were the ancient sources, and the first ancient source of family Hindu law is considered as Shrutis. Now, what is Shrutis? Shruti is actually the sayings of the learned saints about life, how you are going to go, how the life should be governed, all the important morals, values and teachings and regulations has been mentioned under the Shrutis. Now, but when you talk about Shrutis, they are considered as a source of law, but there is no relevance of Shrutis. The reason being of not of relevance being, the reason is that they are not in written format. So since they are not in written format, it was something which is, since it is not in written, so you don't have any proof to say that, okay, since that has been written in regards to your constitution, in regards to your contract, in regards to your criminal laws, you have everything written in a piece of paper and there is a legislation. But when we talk about Shrutis, it is something which has not been written, but rather it has been what has been heard. So earlier what used to happen was that the saint or the gurus used to preach, used to teach their disciples how they have to lead their life, what are the important goals that they should keep in their mind whenever they are going to lead their life. So all these important informations and everything were provided through Shrutis. Okay, but Shrutis, since it has not been mentioned in it has not been mentioned as a written format, it is not of much relevance. And after the Shrutis, it comes the Smritis. Okay, becomes the Smritis. So the Smritis are in written format. The Smritis are in written format. So they have perhaps much more relevance when you talk about the sources of Hindu laws. They are of much more relevance because it is something which has been written. But it is not like that this one has to not deal with what are the different type of Shrutis and what exactly Shruti says. So it was Shrutis it was in the form of songs and poems. The Shrutis were provided as information, and whosoever has heard those songs and poems have understood the Shrutis. Shrutis were majorly classified into 4 things. The first one was Rig Ved. There were 4 Veds which has classified Shrutis. First was the Rig Ved. Second one was the Sam Ved. Third one being the Yajur Ved. And the fourth one, which was added after a later period of time, that was Atharva Ved. So all these things comes under the Shrutis, which is considered to be the very first ancient source of law. But what happened after that? Since it is not in written format, then obviously the relevance is merely of persuasive nature, because you don't have much in writing, so you cannot prove, you cannot say that this is a valid thing according to the Shrutis, because there has been no relevance, because it is not in writing. So then it comes Smritis, as we have just studied, that it is also a source of law. And now why it has been considered as Smritis? Because Smritis are in written format. The Smritis are in written format, so that is why their importance becomes relevant. And all these Smritis has been mentioned in phrases and verses. So verse and phrases has been mentioned under the Smritis, which has provided the different way forward and how to lead the life. And these Smritis also has been further subcategorized or divided into 3 major portions, 3 major types. It is not like that there is only 3 Smritis. There are lots of Smritis, but the important Smritis according to the syllabus of a CLAT is first one being Manu Smriti, second one being Yajna Valkiya Smriti, and the third one being Narad Smriti. So this is just the information that you need to carry, because there are chances that you might be asked that under which source of Hindu law. It was just by the saying that this was just the teachings that was passed from generation to generation, but was not mentioned in a written form. Which type of source of Hindu law is being mentioned and which type of source of law has been talked about. So you need to know. Now you have understood that it is the Shrutis which is not in written format. So once you have the idea, you will be able to answer that question in a very crisp, clear and precise manner. Okay, now Smritis is something which is considered as which is remembered. Remembered of what? So, as I've just informed you that the Shrutis were not in written format, but these were the principles and the values that was provided by the saints to their disciples. So now what the disciples did, that whatsoever they have learned through their gurus, through their teachers, they converted the Shrutis, the disciplines and the teachings of the Shrutis into Smritis, which is known as the things that has been remembered. Now, how the things will be remembered? Because now since it is in written form, it becomes perhaps easier for the person to retain it. So the three major Smritis, I've just explained it to you: the Manu Smriti, the Yajnavalkya Smriti, and the Nara Smriti. We could have dealt in and tried to understand what exactly the Manu Smriti says, what example the Yajnavalkya Smriti says, and the Nara Smriti says. But I won't be dealing much forward into that, because that might not be a question that will be put forward in your CLAT examination. Just to try to make you understand what exactly has been the background of the family law and how the modern sources came into being. But first we need to try to understand the ancient past also. So all these three types of Smritis, Manu Smriti, Yajnavalkya Smriti, and Nara Smritis, has been named by the person who has created it. So the Smriti which has been created by Manu is known as Manu Smriti. Yajnavalkya created another Smriti which is known as Yajnavalkya Smriti, and Narad has created another Smriti which is known as Nara Smriti. So what are the things that we need to understand under the family law in regards to the sources are that these Smritis are written text. So when we say these Smritis are written text, what we need to make sure is that these texts are understood in the way there has been the explanation. When you talk about these Smritis, they are not only providing you with the substantial law, but also the procedural law. What exactly is the procedure that one has to follow if certain accident takes place? For example, the institution of an FIR, what is the procedure? How do you have to approach to the court? How do you have to go to the police? What are the essential documents? All these laws are known as procedural laws. And substantive law, what are the rights of the people? And the Constitution is a best example of substantial law. The Code of Criminal Procedure or the Code of Civil Procedure is the best example of procedural law. So all these things has been mentioned under these Smritis. Once the Smritis has been done, now there was a lot of confusion between the Shrutis and the Smritis in total. The reason being, all these Smritis are of equal weightage. So it is not like that Manu Smriti is of inferior value, Yajnavalkya Smriti is of inferior value, or Nara Smriti is of inferior value. All three Smritis have equal importance. So which one to follow? Whether we should follow the Manu Smriti, the Yajnavalkya, or the Nara Smriti, there was still a confusion as to what exactly needs to be followed. So after the Shrutis and the Smritis, comes a perhaps more comprehensive way forward to find out the important laws which is going to govern the family as such. And we came to something which is known as, I'll just tell you out so that it will be easier for you to understand. Then we came out with another concept, and which is also a source of law, and that is commentaries and digest. Now obviously Manu Smriti is talking about that the woman should not be given any powers, and the Sudras should not be allowed, and Yajnavalkya has given some rights. Narad is saying that okay, a woman should also be treated equally. So all these Smritis were conflicting each other. So there was a need to find out something which can be understood as a relevant portion. So we resorted to another source of the family law, that is specifically under the Hindu law, that is the commentaries and the digest. In that commentaries and digest, you will find the name, one is Mitakshara. Okay, one is Mitakshara. These words are new to you, I understand, but these are very important terminologies that you need to understand, because these laws will help you in understanding how the things moves forward, and how you are able from this 600 BC to the Hindu Marriage Act 1955. How we came from this portion to this portion, and still the laws, the rituals that has to be followed has been still intact, and all the evil sources that were there, that were present, has been removed, so that the people, the Hindus as such, are able to have a happy, safe, and socially acceptable marriages in their particular religion. Okay, so let's come back. The commentaries and the digest. First, the name is Mitakshara, and the second name is Daya Bhaga. So these are the two schools, Mitakshara school and Daya Bhaga school, which studied the Smritis and they interpreted the Smritis for the better understanding and approach towards the laws that is going to govern the Hindu religion as such. If we talk about the family law, first we need to understand that the Mitakshara and the Daya Bhaga school is it is nothing but it is a brief compendium. Okay, this is a brief compendium. When you talk about Daya Bhaga, one fact is that it has been made by a ruler or a king which is known as Vijnaneshwar in the 12th century. Okay, so 600 BC was Shrutis, then came Smritis, and then in the 12th century you find mentions of commentaries and digests. And the commentaries and digests being the Mitakshara school and the second one being the Daya Bhaga school. So Mitakshara and Daya Bhaga school are the two schools of thoughts which have tried to explain the Smritis as such. When you talk about Daya Bhaga, the ruler there, Vijnaneshwar, has studied one Smriti which is known as Yajna Valkya Smriti, which is considered to be the second Smriti, Manusmriti, Yajnavalkya Smriti and the Narad Smriti. And he has studied the Yajnavalkya Smriti and has given a detailed digest, a commentary over the Yajnavalkya Smriti by Vijnaneshwar, which created Daya Bhaga school. So Daya Bhaga school is only confined towards the Smriti of Yajnavalkya. It is making all the important information that was present under the Yajnavalkya Smriti into a school which is known as Daya Bhaga. It is only followed into two places in the Indian territory, one being Assam and second being West Bengal. But the rest of the states follow only the Mitakshara school of thoughts. And what we're going to do is we need to understand what exactly the Daya Bhaga school is saying about. Okay, let's change this. Let's come back again. So this is the sources of schools that we were talking about, the Daya Bhaga and the. Okay. So when you talk about Mitakshara, the Mitakshara school has been created under the 11th century. And the major difference between the Mitakshara school and the Daya Bhaga school that we need to understand here is that under the Mitakshara school, the succession, when we talk about succession, because see, when you talk about Mitakshara and when you talk about Daya Bhaga, it is something that is considered as the source of Hindu law. So source of Hindu law will not only be confined towards only marriage or the divorce. It will be telling you everything, whether it is marriage, divorce, succession, and adoption, etc. So all these informations will be provided according to the these two commentaries itself. But certain people will follow only Daya Bhaga and certain will follow Mitakshara. So in the states of West Bengal and Assam, you will see prominence of Daya Bhaga school, and the Mitakshara school you will see the prominence in the rest of the territory of India. Yes. So this is what we are going to study. But after the Mitakshara and the Daya Bhaga school, it was not like that the things got over. Let me just quickly change this so that it becomes very clear to you. And we will just add one more slide. Here we come, and then we click, and then we move to the next one. Okay, so we have studied the sources of, when we studied the sources of Hindu laws, we understood that there are Shrutis, then we have Smritis, then came the digests and commentaries. Okay, and then after the digest and commentaries, which divided the sources into Mitakshara and Dayabhaga, there was still some confusion that how the things needs to be governed. So for that, there were the need of schools of laws which were divided according to the religions. Not the religions as such, but the regions. Because if you talk about India, you have a different set of customs and ceremonies that you will find in the northern areas, certain different ceremonies of the same Hindus community in southern areas. Northern Indias, you have different ceremonies that needs to be followed. Eastern, you have different. So according to those ceremonies and rituals and customs, there was creation of the schools of law, which were further classified into 5 major areas. The first being the Mithila school. The second one being the Banaras school. Third one being the Dravid school. The fourth one being the Maharashtra school. The fifth one being the Bengal school. Okay, so the first 4 has been under the Mitakshara, and the fifth one, the Bengal school, since I just explained it to you that the West Bengal is one place which follows the Dayabhaga schools of thoughts. So it is the Bengal school where which you will find mention of all these important points. Okay. So these are the things that how, because of the division of the religion, the place has been segregated. And now according to the different schools, for example, when you talk about the northern area regions, we are much more focused over the Banaras schools of thoughts, the Maharashtra schools of thought at that point of time when we subdivided into the different regions. But still there was a lot of confusion as to how the things has to be managed, because the Mithila school was talking about some another customs, another provisions. The Banaras school was talking about some another provisions. Dravid was had another conflicts. So in order to remove all these conflicts, we again came up with some another source. Another source which is known as judicial decisions and legislations. Okay, so judicial decisions and legislations. So when we talk about judicial decisions, we are talking about precedents. So every conflict that used to happen before the creation of the modern sources of law, whenever there was used to be a dispute between a family, between a husband or the wife, it used to go to the court, and the court used to provide the judgment over the same. And once they used to get the judgment, it has the evidentiary value, meaning which it got converted into precedents. So the precedents were also considered to be the source of Hindu law. And there were other legislations that were created by the government at that time, like the Caste Disability Act, etc. The Caste Disability Act of 1850, which provided the ancient sources or the legislation which provided the sources of the Hindu laws. So you have seen there were another laws also, the Hindu Wills Act of 1870, which provided perhaps another sort of legislation when you talk about the sources of Hindu law, the ancient sources of Hindu law. But what we have tried to understand is that all those sources started from the Shrutis, and then it got refined, and after a certain period of time, there was certain legislation that that was started to being created. The Caste Disability Act of 1850, the Hindu Wills Act of 1870 is the evidence to show that these laws were created in such a manner that you have the whole timeline being crystallized and compressed in a very efficient manner in order to get the main crux or the main important sources, the main source of the Hindu laws. But these ancient laws still had a lot of confusions and conflicts. In order to remove these sort of conflicts, there was a committee. There was a committee that was formulated, and that committee is known as Narsingh Rao Committee, which was given the duty that you need to create Hindu personal laws so that these laws will be made applicable to the Hindus, and they will be governed through these legislations only, and not through any other customs or ancient laws or ancient sources, because there was lots of conflicting opinion in the same source that we used to understand. So it is not like that we are not going to refer to those ancient cases, but rather now we have a much more efficient source. So we will be directly referring to that particular legislations. So if you talk about as an advocate, you are not supposed to refer to the Shrutis and Smritis in order to find out what the law says. You can refer to the Hindu Marriage Act of 1955, that how the marriage needs to take place and everything. And if you still feel that this particular law is in conflict by the laws which has been governing the society, then only you are going to refer the sources of the ancient sources of the Hindu law. So this is why it is important for you to understand that post the judicial decision legislations, there was the committee which was formulated in the name of Narsingh Rao Committee, which gave us all the modern sources of law, which the Hindu personal laws, which is the Hindu Marriage Act, the Hindu Adoption and Maintenance Act, the Hindu Succession Act, and all those acts, which the Guardianship Act, which are considered to be the modern sources of Hindu law. Because now you have something which has been created by the legislations and which has evidentiary value. So this is how the sources of the laws has been segregated. We have customs also that is considered to be a source of law. But there are certain requisites that custom should have in order to make sure that that custom is considered to be a valid custom. That is something that we'll be learning in our later classes. But for you, this is more than sufficient to understand that when you talk about the family law and the majorly Hindu law, that what are exactly the sources of Hindu laws. So we have covered the ancient portion and the modern portions. The sources of Hindu laws has been completed. The overview of what needs to be studied in regards to the family law has been completed. Now what we will do is, from tomorrow onwards, we'll try to complete the Muslim laws, sources of the Muslim law. I will be showing you the pictorial representation of how the Muslims has two communities, of one being Shia and one being Sunni, and what are different school of thoughts according to the Shia school, according to the Sunni school, how Muhammad Allah has been mentioned, what exactly is the importance of the Muharram, and everything we'll be studying because they are being considered a source of law. Unlike the Hindu laws, which has now been in a written format and there is a legislation to which you can refer, Muslim laws still don't have a written legislations. So they govern basically through what exactly the Quran has said. And for the interpretation of the Quran, you have the boards, which is known as the Waqf board. So Waqf board interprets the Quran, and you have different interpreters, and according to that thing only, the interpretation and the resolution and the problems gets resolved. So that is what we're going to study in our later classes. But for you guys, as of now, I've completed the sources of law. I've tried to explain you in a very crystal clear and precise manner that what are the important things. For you, what you need to remember from this particular lesson is that what are the types of sources and what are the ancient sources of Hindu law. What is Mitakshar school, what is Dayabhaga school, and how the schools has been divided. Which school follows what, and what is the major difference between the Manusmriti, Yajnavalkya Smriti, and the Narasmriti? Because perhaps these are the only things that will be put forward and will ask in your CLAT examination if you only refer to the sources of the Hindu laws as such. Till then, I would again request you guys to be consistent in your approach towards the planning and preparation for your CLAT examination, and please follow the 3 principles which we have already been explaining to you. Being persistent, following the principles, and be practicing the sessions. By continuous practice, you will make sure that whatsoever you have studied, you are implementing that, and that is how you are going to prepare for your CLAT examination. With this, I would like to thank you all to be present for being present in this class, and we will meet in the next class, where which we will start with our sources of Muslim laws, and then accordingly we'll study the marriage, the divorce, the succession, and the maintenance of both the religion, the Hindus and the Muslims. And then we'll cover the special laws, which have a universal applicability, which can be used by any religion, irrespective they have the Hindu laws or the Muslim laws. But first we need to understand all these things, and then we'll cover that point. Okay, till then, I would like to thank you all again. Bye bye, take care guys.